This next video is going to take a closer look at how the federal court system actually operates. We're going to look at how it's structured, what kind of jurisdictions each different level of the court has, and then we're going to finish up this video with a real quick introduction to what happens as a case makes its way to the Supreme Court. Where we want to start when looking at the federal court system is we want to take a look at what the Constitution says. Article 3 of the U.S. Constitution is known as the judicial article. And as with most topics in the U.S. Constitution, this article is very vague. It doesn't provide a whole lot of specific information. Basically what it says is that there will be a Supreme Court. It'll be the highest court in the land. And that any other courts that we have at the federal level in the United States will be created by Congress. And it also says that federal judges shall serve for life during times of good behavior. It's not really specific about, how the courts will operate. The way that the courts in this country have operated over the years have changed. We're going to talk here in a few minutes about the fact that there's 3 levels to the federal court system. That hasn't always been the case. The U.S. Constitution, originally Congress created just basically one level of courts below the Supreme Court. For many years, the Supreme Court acted as both our appeals court and our court of last resort. But that has changed, as we'll talk about here in a few minutes. The number of justices that we've had on the Supreme Court have changed over the years because the Constitution, again, is not specific about how many U.S. Supreme Court justices there'll be. As we go through here, we'll talk more about what the federal court system looks like today. But just understand what the Constitution originally said about the federal courts. Now, when we talk about federal judges and how they get their job, we must understand that all federal judges are appointed by the President of the United States. I believe in the last video we had mentioned this. Every federal judge, whether they work at the courthouse here in Cape Girardeau or if they work in the Supreme Court in Washington, D.C., every federal judge is appointed by the President and must be confirmed by Congress. More specifically, they must be confirmed by the United States Senate. Now, judges are also appointed for life, but you'll notice I put in parentheses, during times of good behavior. What that means is that if a judge does something wrong, the President can't fire him, the people of the United States can't fire him, but if a judge does something wrong while they're in office, Congress has the power to impeach a judge. No different than the power that Congress has to impeach the President. It's the same exact process. The House of Representatives will impeach, basically indict the judge, saying the judge has done something wrong, and then the Senate will conduct a hearing to see if the judge will actually be removed from office. Now, let's look specifically at what the Constitution says the powers of the federal courts will be. Article 3, Section 1 simply says, the judicial power of the United States shall be vested in one Supreme Court. Very, very short, concise, yet vague statement. What does that mean? Well, what are the judicial powers? They don't specifically say exactly what the judicial powers are. As we look at, the court system and our government today, the Supreme Court has developed a power that we know as judicial review. The Supreme Court has the ability to tell Congress or tell the bureaucrats or tell the President that some action they've taken violates the Constitution. But if we read the Constitution, that power of judicial review is not explicitly listed there. So how did the Supreme Court acquire this ability of judicial review? Well, very simply, there was a court case in 1803 known as Marbury versus Madison. The summary of the case is on the screen. And basically what happens was an outgoing president had appointed some people to be judges. The person that was supposed to deliver those appointments did not deliver them before the next president came along. And the next president refused to appoint those people or honor those appointments for judges. And this gentleman by the name of Marbury took this to the Supreme Court and asked the Supreme Court to say that the appointments that were made by the previous president should be recognized, and that when the new president refused to seat these judges, the new president was violating the Constitution. Well, the Supreme Court had a problem there, because if the Supreme Court makes a decision and Congress nor the president listen to them, if Congress and the president just ignores what the Supreme Court says in 1803, the Supreme Court is going to be a very, very weak institution. So Chief Justice John Marshall came up with a very creative answer here. And instead of ruling on whether or not the president should have recognized those appointments, rather the Supreme Court decides that the Judiciary Act of 1789, which created all of these judgeships that needed to be filled, was unconstitutional. The court, under John Marshall, for the first time, tells Congress, something you've done, the Act of 1789, is unconstitutional. And Congress accepts the court's decision. And by accepting the court's decision, they create precedent, which means from 1803 forward, every time the Supreme Court says that an act of Congress is unconstitutional, Congress obeys them. The president obeys them if they're told that the president has done something unconstitutional. So the judicial review power that that the court has is something that they've acquired. There could be an argument here that this power of judicial review is just that, a power, and not an authority. Interesting point. Keep in mind what Marbury versus Madison deals with, and keep in mind what judicial review is. When looking at the current structure of the federal court system, for the most part, it is a three-level system. Starting at the top of our list, which is actually the lowest level of the federal court system, you have district courts, which are also known as trial courts. Then you have what's called the circuit courts, or the courts of appeal in the United States. And then, of course, you have the Supreme Court, which is our national court of last resort, which means if you take a case to the U.S. Supreme Court, there's no place you can go after they give their ruling. That's it. We're going to take a look at all three levels of the federal court system. We're going to take a look at which each level does, and we're going to take a look at the general structure of each of the three levels of the federal court system. First thing we want to do is take a look at this organizational chart on the screen. And really what this is, it's an overview of what the federal court system looks like. And you will notice that there are more than 3 different courts on this screen. But what you should know is that we basically break the federal court system down into 3 levels. The first level is the ones on there that are of the light blue. Those would be considered trial courts for the most part. Then the second level, the kind of the purplish, would be courts of appeal. And then in the light blue at the top is the U.S. Supreme Court. Now, when we also look at this chart, you'll also notice that there are state courts of last resort that are off to the left side of the screen. What that means is that if a case starts in the state court system, it could actually make it into the federal court system. But if a case from the state courts is going to make it into the federal system, it will never come into the federal system through the trial courts. It will always come through an appeals court or the U.S. Supreme Court. When we look at each one of these different levels of courts, we have to understand that each level of any court system, but in particular each level of the federal court system, has a different job that they're designed to fulfill. And when we talk about the job or the responsibility of the different levels of courts, we're really talking about something that we call judicial jurisdiction. And when we talk about judicial jurisdiction, we're simply talking about which level of the court system has the authority to hear the case. There are certain cases that have to start at the first level. There are certain cases that can start or have to start at the Supreme Court level. Each of the three different levels of the court system has a different jurisdiction or different job. The two different types of judicial jurisdiction we'll talk about in this video is original jurisdiction and appellate jurisdiction. And original jurisdiction is very, very basic to understand. Original means the first. So a court with original jurisdiction is going to be the first court to hear the case. If I am charged with a crime, which court is going to be the first court to hear my case? At the federal level, the district court most of the time has original jurisdiction. If I'm charged with violating criminal law or violating civil law, my trial is going to start at the district court level most of the time. That's why we call the district court the trial court. Now, there are a limited number of situations where the Supreme Court has original jurisdiction. There are some cases that have to start at the Supreme Court level. And a perfect example of that is the president's impeachment trial. If the president has been impeached and the Senate is going to try him, the Supreme Court acts as the court of original jurisdiction there. There are some other situations. Treason would be a case where it would have original jurisdiction in the Supreme Court. If the state of Missouri is suing the state of North Carolina, whose laws do you use? Do you use Missouri's laws or do you use North Carolina's laws? The Supreme Court would step in and act as the court of original jurisdiction in that case. But you have to realize that probably 95% of the time or better, the Supreme Court is not using original jurisdiction. Most of the time when the Supreme Court is hearing a case, they're hearing it because they have the second type of judicial jurisdiction, and that is appellate jurisdiction. When a court is exercising appellate jurisdiction, their job that they're doing is they're simply hearing arguments about whether the decision of a lower court was appropriate or not, whether or not some lower court violated the due process rights of a defendant. So obviously the appeals courts will have appellate jurisdiction because they are the appeals courts. The circuit courts are known as appeals courts. They have appellate jurisdiction. Anytime that the appeals court is dealing with a case, they are dealing with an appeals situation. Appellate courts at the federal level will never have original jurisdiction. Circuit courts or the appeals courts only have appellate jurisdiction. Now, if I have appealed my case all the way to the Supreme Court, then the Supreme Court is utilizing its appellate jurisdiction. And again, most of the time the Supreme Court is using its appellate jurisdiction when it's making a decision. So of those three levels of the courts, district courts have only original jurisdiction, circuit courts have only appellate jurisdiction, and the Supreme Court has both appellate and original jurisdiction. and looking specifically at the district courts in the federal court system, we need to realize that basically what has happened is Congress has broken the United States down into 94 specific districts. And if I am charged with a crime, or if I go on trial in this country, my trial is most likely going to happen within the district where I was accused. So I'm not going to be accused of murder in North Carolina and wind up having my trial in California, for example. We break the country up into these 94 districts. Each of these 94 districts are known as trial courts. And the reason that we call these the trial courts, again, it's usually the court that has original jurisdiction. And before I can be convicted of a crime, there has to be a trial. So the vast majority of all trials that take place in the federal court system happen at the district court level. When I'm on trial, there is only one judge. At the district court level, there's one single judge, and that judge oversees the trial. And remember, the judge is there primarily to ensure that the defendant's due process is being protected. Something else that we'll notice at the district court level, it's the only place where you will find a jury, for the most part. It's the only part of the federal court system where witness testimony is heard. It's the only place in the federal court system where you really truly have guilt or innocence determined. There is a limited number of cases, again, where the Supreme Court will act as the trial court or the court of original jurisdiction. Then all of these things will apply at the Supreme Court level. But when a trial is conducted in this country at the federal level, the vast majority of the time it's going to be done at the district court level, and there's one judge that oversees the trial. It's the only place where a jury will be present. It's the only place where you hear actual witness testimony, and it's the only place where guilt or innocence will be determined. Basically, it's the only place in the federal system where a true trial will take place. When the trial is completed at the district court level, I can either be found guilty or innocent. And if I'm found innocent, I go free. And if I'm found innocent by a court, then the state can never retry me for that charge again because of the double jeopardy standard. Now, if I am found guilty in a district court trial, then my sentence is imposed. And if I'm sentenced to go to prison, I go to prison. Now, while I'm in prison, my due process rights haven't been eliminated. If I'm found guilty and sent to prison, I can still challenge that trial that I had. Let me give you an example. Let's say that I'm on trial for murder, and there's a person by the name of John Wilson who could testify that I was not even in town when the murder took place. I was in Jefferson City with him. If the prosecutor thinks that John Wilson is an unreliable witness, he could ask that John Wilson not be allowed to testify. And if the judge says, I agree, John Wilson should not be allowed to testify, my attorney is going to say, I object. And what that means when my attorney objects is that he believes that my due process rights have been violated. Now, if the judge says, no, we're not going to let Mr. Wilson testify, the trial continues. And when I'm found guilty and sent to prison, what me and my lawyer are going to do is we're going to file an appeal. And we're going to say that Mr. Sexton's due process rights have been violated. And they're going to say, I believe his rights have been violated because Mr. Wilson should have been allowed to testify. I'm going to stay in prison while I'm appealing this. But my appeal is going to be sent to the appeals court. And it will be one of the 13 appeals courts in the country that will look at my situation and determine whether or not my due process rights were violated when Mr. Wilson wasn't allowed to testify. Now, this is very important to understand, that when an appeals court is hearing a case, the appeals court is not deciding guilt or innocence. The appeals court is simply deciding whether or not my due process has been violated. And if the appeals court decides that my due process has been violated, they don't find me innocent. The appeals court simply throws out my conviction and says, since the trial that Mr. Sexton had violated his due process rights, we're going to throw that trial out, and then we can retry Mr. Sexton with a new trial, and the mistake that was made the first time should be corrected. So understand that when you make an appeal from the district court to the appeals court, you're not necessarily appealing your guilt or innocence. You're appealing the process by which you were found guilty. And if the process by which you were found guilty is flawed, according to the appeals court, then you're given a new trial. It goes back to the district court, and there'll be a brand new trial. The appeals court is structured different than district court, in that instead of there being 94 appeals courts in the country, there are what we call 13 circuits. The country is broken up into 13 little regions, and if I have a trial in the 35th district court, and the 35th district court happens to be in the 12th circuit, my appeal from my district court trial is going to be heard in the 12th circuit. Again, if I appeal my decision, I don't get to pick the appeals court that hears my appeal. The appeals court that's going to hear my appeal is going to be the one in which my original case was heard. In the appeals court process, there are usually 3 judges that will hear an appeal. And a majority of the judges have to agree before they'll determine whether or not my due process rights have been violated or not. So if 2 judges say that my due process rights have been violated, I'm given a new trial. If 2 judges say that my due process rights have not been violated, then my conviction stands and I stay in prison. Remember, the appeals court only has appellate jurisdiction. Now, if I'm in jail and I appeal my case and it goes to the appeals court, and the appeals court says, no, Kevin's due process rights have not been violated, I stay in jail, but I can then appeal my case to the Supreme Court. And basically the way the Supreme Court works is there are 9 judges or justices. If the Supreme Court decides to hear my case on appeal, they're going to answer the same question that the appeals court answered, and that is whether or not my due process rights were violated. If the Supreme Court is hearing a case of original jurisdiction, then the Supreme Court will determine guilt or innocence. But remember that the vast majority of the time that the Supreme Court is dealing with a case, they're dealing with appellate jurisdiction. Now, how many cases make it to the Supreme Court every year? Remember, we said there's about 101 million cases each year in this country. Out of that 101 million cases, about 80 or 90 of them actually get appealed and accepted by the Supreme Court. So there's a very, 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 very small percentage of the cases that are heard in this country that the Supreme Court actually hears. Now, there are 2 more videos that are online this week that deal specifically about how a case gets accepted by the Supreme Court and what the Supreme Court does when they actually hear a case. Make sure you watch both of those videos, because those videos are fair game for the exam and the final exam.